Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session I want to talk about negotiating settlement agreements from the perspective of the employer. There is a separate video dealing with from the perspective of the employee. I'm just going to share some of my top tips, not all of them, but enough to whet your appetite. So, just like I said in the employee video, as employer, you also need to be aware of your bargaining position and what you've got up your sleeve. So there will be a big difference in negotiating a settlement where perhaps the employee has done something wrong that you might otherwise be pursuing the disciplinary procedure over, or has not been performing and you might otherwise be following a performance management plan, compared to a situation where you are on shakier ground, perhaps where there isn't so much of an obvious reason why somebody might otherwise be leaving, but nevertheless a decision has been made that your preference would be to achieve that outcome. So it's about thinking through what the pros and cons are of your position, getting some legal advice and making sure that that informs the tactics that you're going to take. I would say ask your lawyer to review your proposals with their employee hat on. So look at your settlement agreement. Yes, you'll have spent a lot of time thinking about, does it have the right gagging clauses in it, and does it address the return of our company property and all the things that you worry about? But does it actually deal with the things that the person that we're going to be sending it to is likely to be worried about and thinking about? So I'm thinking about things like references and announcements, not making derogatory comments about them, the return of their own personal property, things like whether they get to keep phones or laptops, what they can say. So confidentiality may apply to the situation, but what are they going to say to the next employer or the recruitment agent when they're going out there into the marketplace? So actually, by a little bit of that boot on the other foot mentality, we can come up with something that is more palatable, that makes the person feel that we have thought about them, and should lead to a smoother process and potentially less legal fees as a result. So it is worth getting that right. I would say don't ignore the bits and pieces. So we tend to think often in terms of notice pay, holiday, termination payment, something tax-free, that kind of thing. Let's not ignore all the other bits and pieces that somebody has. So pension, medical insurance, any other benefits that they currently enjoy. That might be shares, it might be share options, whatever it is. We need to make sure that we're covering off all those bits and pieces, because you can guarantee that the employee will be thinking about those things. So we're better off addressing those things. Now, sometimes you might decide that you're not going to offer something immediately because you're prepared to negotiate on it and you want to have that give and take, but you need to at least be thinking that through before you do it. Legal fees. The going rate that I still see people offering in settlement agreements for legal fees was the going rate 23 years ago when I started this job. So employers have definitely not caught or kept pace with what legal fees are likely to be, and it just leaves a bad taste in the mouth of the employee if not only have they been exited from their job and having to deal with all the emotional stuff around that, but if their employer can't even pay them the right amount of legal fees so they're not out of pocket, then that does leave that person leaving with a bad taste in their mouth and not going to say good things about your organisation in the marketplace. So sometimes it is worth just putting a bit more money into the pot in that regard. Those are just some of my tips. I may do another one of these videos with more sometime. If anyone's got any questions, adenton@refreshinglawltd.co.uk. Thank you very much.